is case by case and, try to help them as much as we can.
Well, I think this whole thing started was because we were having solar systems that are butting each other. And also, we were, and I remember asking this during the landfill in North Carver, wondering if we could reduce some of the setbacks if the property owners that abutted the solar array would give relief. And we did ask the neighbor one time, I believe, and they said no. So we held the 200-foot setback. But I think basically this was for, and I guess it can go on to other purposes too, but it was basically for cranberry growers that say either had owned a piece and then another cranberry owner, and we've run into that too, where we've had two solar systems that were abutted, and they weren't owned, they were owned by individuals and separate individuals, and they had to spread them out 400 feet. And so that's why this came about.
Mr. Chair. I think this zoning amendment that's proposed meets a majority of our concerns throughout the season, throughout the year. So I'm gonna vote, I'm gonna make a motion to recommend to the zoning amendment number 1 as written for town meeting.
What about the multiple parcel stuff? Even if you reject the
As
direct
as
abutters
it's
thing?
written. That was my motion as written.
I'll second that.
Wait, does that take into, because in Part C, I'd raised it to Stephen before, the multiple, instead of it's like
Yeah.
contiguous or
Oh,
adjoining
excuse me.
or.
Yes,
the
the
neighboring-
continuous parcel language, I'll amend that in my motion, but yes.
Okay, not this as written.
Right,
Okay.
it'll be this article with changing that multiple to continuous parcels.
Okay.
Sorry, I missed that. No, I appreciate you pointing it out, because I would have missed it.
So we have a motion and a second. Any further discussion? Hearing none. Those for?
Aye.
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 And those against?
No,
Okay, so it was 3, 4, and 1 against. So we'll go on to zoning amendment 2.
Mr. Chairman, this is part of the same narrative of the task that the Economic Development Task Force had worked on, recognizing that arrays on bogs are slightly different than the traditional amounts that we mentioned earlier. 2A would add a new section to the bylaw. That's section 3580.7, and it speaks specifically to the dual-use arrays operating under the SMART incentive program as created by the state. You can see on the second page of your packet, it has a use regulation chart or dimensional chart that specifies that in residential agriculture districts, if the height is 8 feet or greater, the setback shall by default be 200 feet with a 100% screening requirement and 300-foot abutters notification. That's in fact effectively exactly as it stands today. With the 2 asterisks that have been included, that means that the planning board may reduce setbacks, but in no instance shall setbacks be less than 25 feet, and that infers the 25 feet in aggregate, the 12.6 on each side of that. Frankly, that's poorly written there, but we can correct it. When abutting a residential agriculture district, and 100% of screening shall be attained from the grader of abutting street grade or yard grade. Part of the conversation, taking into consideration the topographical situations. The task force thought it would be best for the planning board to exercise some discretion with regard to topographical situations. What we mean by abutting street grade or yard grade, whichever is greater, we recognize that some people's yards may be a little lower or higher than the street grade. So if the street grade is higher, that's the higher threshold from which we have to achieve the screening. 2B specifies that the planning board is allowed to reduce the setback to a minimum of 12.5 feet if arrays are abutting a bog or other agricultural use as defined by the general laws, chapter 128, section 1A. provided that these standard setbacks and screening requirements are waived in writing by all the direct abutters in a res-ag zoning district. 2C will allow the setbacks to a minimum of 25 feet, provided standard setbacks and screening requirements are waived in writing by all direct abutters in an RA zone district. That is not a bog. That should specify that is not a bog. Yes.
How come this is going down to 25 feet when zoning amendment A, or zoning amendment 1, part 1A only goes down to a minimum of 50 feet when a bog's not involved?
One speaks to the traditional ground mounts, the traditional units. We're not gonna see less of those. We might see less of those, frankly, but they're never gonna go away. So Article 2 speaks specifically to a dual use. So when it's on a bog and abutting a bog, that's really where the planning board is allowing, that's where the task force is allowing the discretion. For Article 1, it's either new bogs that are being proposed and adjacent to existing bogs, arrays and adjacent to existing arrays, or in an instance where it's abutting a residential use, not an agricultural use. See, one of the things that we have complications with in town is that we have two residential agricultural constituencies. There are those people who live in res-ag and only live in res-ag, and there are those people who operate and live in res-ag as growers. Very different interests, though, especially when it comes to solar, as you can imagine. So the first one, Amendment 1, gives the planning board discretion for the traditional ground mounts to reduce it to 50 feet. And in the instance where it's in mutual ownership, it can be reduced to 12 feet 6 inches over the lot line. For number 2, or Amendment 2, it speaks almost specifically to abutting bogs, projects on bogs, or agriculture use.
Is that what it says when it says when abutting a residential agricultural district? That sounds like it can be no instance less than 25 feet when abutting a
So
house.
it's in reference, are you talking about 2B?
Then the chart, the asterisk,
Mm-hmm.
planning board may reduce setbacks, but in no instance shall setbacks be less than 25 feet when abutting a residential agricultural district. That doesn't specify a bog. So I feel like that should be 50 feet, so it can,
If you look at 2B, it specifies general law, chapter 128, which is the agricultural use.
okay.
This was just a chart for discussion purposes. It won't appear in the bylaws. It's just what came out of the task force's recommendation. That 25 feet is the 12 and a half feet on each side of that property line. That's what was being cited there.
So I know I wasn't allowed to be on the task force, but I went to some of the meetings, and there was a discussion about different heights of the bogs having different setbacks and stuff, and I had a concern. I talked to you about it, Stephen, about the numbers feeling arbitrary, and if it's a certain height, you go back a certain distance, and the screening has to be yay high. You go back further, the setback can be different, and it's yay high. This is a much more simplified version. I'd just like to know if real-world experience was done. I'd like to know that we got out there, someone got out there and went on a field and said, okay, I'm 200 feet back, let's put up an 8-foot solar panel. Okay, now let's put up a 12, now let's put up a 16, and actually see what it is, as opposed to seeing the numbers on paper. I feel like it'll look different in real life than maybe we envision on this. So I would like to have seen more, not experimentation, but I guess justification or reasoning for those numbers.
So, through you, Mr. Chair, and maybe this will help and maybe it won't. Correct me if I'm wrong, Stephen, this is addressing to the new dual-use array. This is the elevated arrays that are above the bogs. This board had approved previously off of Gate Street, a solar project that's elevated, that addresses a lot of these concerns that are in this. Number one, the arrays were gonna be elevated above the 8+ foot mark to address the dual use between cranberry growing or whatever they're gonna do for agriculture there. I don't think they had a specification at the time. And also the screening, as we went out to that site and looked at that site, we were on the road access coming in, and that was way back and we had talked about, would there be screening necessary from the street view coming in, and this board said no. And so I think that this is more looking at that aspect of that type of array. I could be misspeaking, but that's the way that I'm taking this. Did I say that right? Sounded good.
And I would only say further still, that project that was mentioned, because of topography, it was the will and wisdom of all of the members of the board that they actually could relax some of those screening provisions and landscaping requirements that they had actually installed in their plan initially themselves. So it does demonstrate that topography can go the other way as well, that it could work in the favor of the project. You asked a great question, Jen, and in fact, I don't know if Mr. Ward is here. Is Dick? Hey, Dick. So Dick Ward opened up his bog for me so that I could take a look at a perfect example, so to speak, where the bog is recessed lower than even the cart path, which is even lower than the grade of the street. And so this thing is a little bit of a bowl, so to speak. And Dick, I'll defer to you if you want to describe your property a little bit better. But it seemed to me that this was a good example of something that would be completely screened, you know, almost a mile radius away. Unless you're on a fire tower, you just certainly wouldn't see it. There were a couple of other instances, I can't speak for the other members of the task force, but I believe there were 13 members. Most of those folks had reported back, and it's in the minutes, that they had done something similar as well. So you're right, we had started with the idea of a sliding scale basis. Ultimately, that was pared back to what you see here, and that was through the collective action of that task force, largely also through some of the site visits conducted by those members, and myself included.
Like I said in the previous one, there's a lot of instances it'll make sense, but in the instances where residents in their personal property from their houses are concerned, where it's not so clear cut, I would be more comfortable accepting more stringent language as opposed to leaving it so open-ended, which with flexibility in either setback or screening, that could really vary. I'd like to see stronger language. Although there are going to be some instances like Gate Street where it is very obvious based on the topography, the location, and what's around it, that the setbacks and the relaxation is fine. I wouldn't know exactly what to suggest as far as language goes. I would have supported a stronger setback and screening requirement, leaving some room for variances from the board.
The only thing I'd say is that anyone looking at a map of Carver can see that many bogs abut other bogs. And I think that's what we're trying to take into consideration here. Mr. Chairman, you had mentioned earlier, one of the common problems, as the laws are written presently, if an array wants to go up next to an existing array, be they both on bogs or otherwise, it's a 400-foot setback with 200 foot of landscaping in between. And now, in this instance, there are no abutters in between in this no man's land who would be impacted visually by this in any way. And so in that vein, to require screening for a bog abutting a bog or an array abutting an array, it doesn't achieve anything. I think what we should be focused on as a board and as a staff are the areas where, either in the public right-of-way or from a residential abutter's perspective, how do we achieve that screening? I believe that Amendment 1 and Amendment 2 that's before you, it solves for that. It corrects those things that the initial solar bylaw didn't take into consideration.
Can we specify that screening has to be natural vegetation? So having a stockade fence or something like that is not necessarily adequate?
The way the existing bylaws are written, if the setback is greater than 600 feet, all you need is a setback, is a stockade fence with minimum landscaping.
Well, that's a
I'm above
suggestion.
verbatim.
That's
Right, it's
not a,
suggestion.
that's not a requirement, that's a suggestion. So if we're adding a new I'd love to see natural vegetation stressed more,
I
because
think-
that's clearly the most desirable screening option. So if there's going to be relaxations to it or any sort of new standard, I really think the screening that has to be put in place when it does should be the most natural possible.
Mr. Chairman, may I, through you, Mr. Robinson, you dabble in landscaping, I understand. I'm curious, natural vegetation, how tall would a scrub pine grow?
It could grow more than 30 feet,
More than 30 feet?
but, I mean, that's the idea of it, is to stay low, to achieve being blown over.
Mm-hmm.
Cold winds, the
It's not-
soils that it's gonna be set in, so that, I mean, I understand that that is ultimately the best type of screening opposed to a stockade fence.
Right. And that wasn't leading any question, leading the witness, frankly. I was just trying to understand. It does seem that through fencing and natural vegetation that we sometimes achieve that screening desire that some of the abutters have actually approved and appreciated also. I don't know if it's prudent to specify just natural screening, given how long would it take for a tree like that to grow to 30 feet or large enough to shield an 8-foot array?
A lifetime.
So in that vein, I would just say that I think there's a combination of things that can be done to achieve the intent in the screening.
I just think you're gonna see a lot of people coming saying, I'll put up a white fence, I met the bylaw.
Well, so far that hasn't happened. I mean, we've even had berms, we've had trees and bushes planted, and along with fences too. So we've had a combination of different things. But then, again, it's every project that we see, it's different. The topography's different. The, the people that live around there, some are closer, some are far away. So it's something that we have looked at every project, and everything is in a standard way that we've looked at these things. We've done a combination of things. So it all depends. But I think, I don't know exactly, do we have a definition for screening? Is there a definition that we have?
It specifies vegetative screening or plantings, as well as fences. It doesn't prescribe.
Combination
but
of things.
Correct.
Yeah.
It does allow for all of those things.
Yeah.
And
The
again,
truth be-
we're going
truth be
case
said-
by case, are we not?
Case by case, and if there was a building or an architecture style that we didn't necessarily like, or even the dumpsters or some of the other things that help a business run, we typically have them screened, but behind a picket fence or some kind of a fencing with some combination of plantings as well. The idea is you can see the fence or the plantings, but you're not supposed to see what's behind it.
I mean, we've had some where we've used wire fence, we've used wood fence, we've used berms, trees, so it's a combination of many things.
Chain link fences come in different colors as well, that can be more conducive to the color characteristics of an environment. There's some creative controls that we can take on an administrative side, certainly. On a
So-
case-by-case.
If I can interrupt, in the existing bylaw as it states today, and I think this will help you, under 3580-.60, special permit, it says, in the event the special permit is required for the license, the planning board may grant a special permit and the following conditions are met. I remember bringing this up, that's why it jogged my memory. Such use will not nullify or substantially degrade from the intent of the purpose of the bylaw. Number two, such will not constitute a nuisance. Number three, such will not adversely affect the neighborhood in which it's cited. Four, such use complies with the standard of the site plan review as spelled out in its bylaw. And number five, the planning board may also provide for other conditions that it deems necessary. Those couple of conditions there will give us the ability to say, just because you think you can have just fencing, we deem that we want natural buffering. It's already here, so it's covered.
Oh, I would just like to see it specifically done. In that task force, there was a member on it who repeatedly over the course of many meetings kept saying, I want to see the planning board have some control, but I don't want to see them have too much because you don't know what members are going to be in there in the future. And while I trust the board that's in now, I don't know what's happening in the future. So having the flexibility to do that is great and it's key. But you don't know what's going to happen in the future member-wise. You don't know what's going to come before us project-wise. So while everything's been met, I think to mandate more vegetation, if not 100%, is not a bad thing.
No, but I agree with you to a certain extent. If a proposal comes in front of this board and we go through all the conditions that the applicant brings forward, they've reached out to the community, we've heard from the community, and we've reached all the concessions, and the design features that's gonna, by the bylaw that was adopted by town meeting members, what's the difference whether or not we have the ability to tweak it that's specified existing today in our bylaw than just mandating a natural vegetation? Because if you mandate something, it means that they must put in. There's no give or take. There's no variances. I understand, I was at one of those meetings of that subcommittee that was saying, I don't think that the existing board will have any issues, but boards change every day. But it's also the will of the community on how they want their zoning bylaws designed, right? It's not just one person. It's not just one board member here saying how it is. That's a bylaw that's been adopted by this community for years. And those bylaws, those sentences that were put in place was to give a little bit of wiggle room, also to give strength to this community, saying to a developer, to an applicant, to a for-profit entity to bring a commercial project in here, that you must do this, or we have the right to say no and turn it down, and we have legal basis to fight that in court. Already existing today. But if you say that, okay, I want natural buffering and no fencing, so now you're gonna have natural buffering on that being installed, which could be restrictive to not only the adjacent characteristics of the residential application, but also could be restrictive to our industry in a whole. When I say that, I'm mostly representing the cranberry growers. It could be too restrictive for them to do that. Just a thought. I think that, in my opinion, and only my opinion, I think that the regulations that are existing today gives us that variance. I understand, I respect your thoughts on only allowing natural buffering.
Well, and I'm not saying only, but I think it would be nice to see more of that mandated, so you're not going to get an open door of people saying, I'm gonna put in this fence, I'm gonna put in this fence, because I think you'd be hard pressed to find someone in the community, someone who probably voted for one of us, to say, yeah, a fence is great, don't worry about trees.
Yep, I agree.
I think natural's probably always gonna be.
And I,
Preferred.
and this
But
is
we
a,
have the discretion that you just brought up. We do
I know,
have
I'd
that
just like to see
discretion.
it stronger, so maybe we have less discretion.
and this is a perfect example of that, what you brought up as boards change brings different views and different ideas of what you're gonna bring to the table as an applicant comes up, and you've shown that, you know, listen, I want to see this. That law right there that sits and exists, voted by the town people, give you that right to say that. And have balance to say that. So that's good.
Yeah,
But I think it's already there.
okay.
I think, as we have gone through these projects, we've taken a look, we've looked at where they are on the streets, what neighbors can see it, what neighbors can't see it, the existing screening, and I think, I think the way it is now, I understand what you're saying about the boards, but I would think that all board members would be, want to make the abutters happy, and we've done that, and I think to restrict it to different things, I mean, we have we can do multiple things, like I explained before, so, and we have, and I don't think that we really need any more restricting bylaw on this.
So just for clarification, Mr. Chair, back to Stephen. This new section for smart dual array zoning amendment is specifically addressing the dual array 8 foot above and allowing, with the asterisk is allowing us, as a planning board, special grant authority, whether or not we can allow the setbacks restrictions.
To allow them, not to require
allow
them,
them.
but remember, we still start at 200
Per-
feet. And the planning board, per the way this is written, could reduce it to 25 feet, or 12 and a half feet.
Or somewhere in
Correct,
that.
and from 12 and a half feet to 200 feet.
With written permission from the abutter. So that, I think that's pretty good. I think that, you know, if an abutter, and a lot of times it might be another bog owner or maybe a landfill area, town-owned property that we don't see. If that abutter allows us to do that, then fine. But then otherwise, it's gonna be 200.
Well, if it passes this way, if only the direct abutters need to sign off, maybe it can't get written in, but I would impress upon this board and any that may come in the future that the people who don't directly abut these things, but that can see it and from the public ways be taken into equal consideration. Maybe you didn't get to sign off on it, but if you're driving down the street, you see it, you should be taken into consideration the public ways. If you can see it over your neighbor's yard, you should be taken into consideration. So hopefully, if that's the intent of the bylaw, that's great, I just hope it's upheld. That's why I like to see things in writing, make them stronger.
Well, we do notify the abutters, and it's within a certain feet of the project, so it might include the people in back or the people in back of them too.
Yeah.
And then we do have a public meeting on all these things, and not, although not everybody's notified, but these meetings are published. So anybody in town can come to these. They don't have to be in a abutter. They don't have to get a green card or, you know, a notification. So, and we listen to everybody, so that's the way I feel. Oh, was there anybody else that had any other?
We haven't heard from the public, that's all,
Oh, on this one?
on this app.
Yeah. Okay, we're going on to the public. Does anybody else have anything additional to say about this particular bylaw?
And Steve, you'll be happy the mic's on.
Is that better?
That is.
Steve Ward, 46 Miles Standish Drive. I just want to make sure that you understand that the bylaw is staying the same, and it just gives you folks the ability to give some leeway. So we just want to make sure that we have my neighbor who has a solar field, and I have a solar field. We don't have to put 4 rows of trees in between us. So.
Thank you. And I think this, what the spirit of this was, this is why this was created. It wasn't necessarily to encroach on people in a residential neighborhood. It was because of other growers or other people that had solar arrays, so we wouldn't have to space them 400 feet apart. Anybody else?
Hi again, Savory Moore, 12 South Main Street. I just want to bring up the fact that I think that we've all been aware that the solar companies that have been coming into Carver have been good neighbors. And with these lessening setbacks, they stand to make more money if they can put in more panels. So they're going to be even a better neighbor because they will realize that the abutters have the ability to say no. So I think from the standpoint of screening, that they're going to listen to the community and they're going to do whatever they have to because they want to make sure that everybody in this community is on board with what they do and that they do a good job of making everyone happy. Thanks.
Thank you. Anyone else?
Gotcha. Thank you.
Okay, that's it.
Mr. Chair, I make a motion to recommend for town meeting zoning amendment number 2 as presented.
So you have a motion, do I hear a second?
I'll second that.
So you have a motion and a second. Any further discussion? Seeing none, those in favor?
Aye.
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 Against?
No.
Okay, so that's 3, 4, and 1 against. All right, zoning amendment 3.
Mr. Chairman, if I may? I just, for folks watching at home or in the audience, just to clarify, the rules of the planning board and the bylaws don't allow Ms. Dayhill to voice vote on matters that aren't special permits. She's still nonetheless allowed to contribute to the conversation. In case there's any queries about why these votes are coming down 3-1.
Okay, thank you.
Thank you, sir. No, 3-4 in favor of, 1 against. Okay. Oh, yes, I'm sorry, sir. Yes, I forgot you had moved on to Amendment 3. Frankly, sir, Amendment 3 is really just a correction of a Scrivener's error. If you look at the use regulation table at the beginning of our existing zoning book, you can see that there are times when SP, SP asterisk, SP hashtag appear. That indicates where an applicant has to go in order to receive a special permit. In the use regulation table, SP with an asterisk infers the planning board. If you were to go to the section under industrial that has large-scale ground-mounted solar photovoltaic installations, all that appears is SP with some footnotes, thereby inferring that, looking at this, it would be the ZBA. The text, however, of the bylaws specify otherwise. The purpose for Amendment 3 is to just correct that Scrivener's error and to make sure that the use regulation table includes the asterisk so that it's in conformity with the text and context of the bylaw itself.
Any questions by the board members?
We're adding an asterisk as an amendment.
A few of them.
We technically could have done this administratively. Frankly, I believe too much in transparency.
I just wanted to make sure.
Yep,
Understood
it's
that.
just a correction.
Any discussion? None of the board members? Okay, anybody in the public have anything to say out in the audience? Seeing none,
Mr. Chair, I make a motion to recommend zoning amendment number 3 as presented.
I'll second.
so we have a motion and a second. Those for?
Aye.
That was unanimous, 4.
Unanimous,
All right, zoning amendment 4.
Mr. Chairman, this is informed in part and parcel. Let me start this way. Part of the task of the PEP department, Planning, Environmental, and Permitting, is code enforcement. Our building inspector, our wire inspectors, myself, we become inundated with calls about commercial wood processing operations occurring throughout town and in places where it's very cozy. They're very close to their neighbors. There are noise issues as a result. There's some question as to whether or not there's an adverse impact to property values surrounding an area like this. I've made some of the planning board members aware of some instances in town where this is the case. This is not a discussion on punitive action, and it's the opinion of the planning staff that these types of operations should be allowed in town. In fact, it's conducive to the right to farm that Kara had mentioned earlier. In fact, there are some wood operations and processing operations that are exempt in the agriculture chapters of the state statutes. That said, the purpose for Amendment 4, including the use regulation table, is to codify them in a way that I believe makes them safe for the operators of the facilities, for Carver Fire Department, noting that these types of businesses can sometimes produce combustible materials. And further, I think it's going to protect property values. What you see here is that the commercial wood processing operations would be allowed in all districts, but for the Spring Street Innovation District, the village business, and general business, on a minimum site requirement of 5 acres in all districts. This doesn't necessarily preclude someone from operating on less than 5 acres. They still do, of course, have an appeal mechanism with the ZBA for a dimensional variance if necessary. Reading through this, however, we have come up with a definition that is in line with not only U.S. regulations and code, but also United Nations regulations and code. The purpose is fairly clear, and there's some applicability which exempts those uses or those operators who are exempt in the agriculture bylaws. Lastly, there's a paragraph here on the next page just above setbacks. that speaks to the storage and setbacks from other piles of this Class A material, as well as volumes. This particular paragraph is taken right from the policies set forth by the Carver Fire Department. There's some really important requirements in there, such as if you have a pile of wood chips on site, regardless of its volume, adjacent to that site needs to be a designated area where the piles can be turned over in the event of an incident. Right now, none of this is regulated. None of this is codified. So I believe that if it's the will and pleasure of the planning board to make this recommendation to town meeting, that my suspicion is that town meeting will likely review this favorably as well.
This is new to me. Can you give me an example of one of these, like you'd mentioned other planning board?
I would be glad to do that offline, Jen, but like I said, I don't want to create any problems for people who are
Okay.
operating presently, but there are code enforcement issues that
So these people, are they cutting down trees on their property and turning them into wood chips?
and importing them as well. Now, this recommendation came out of the Invasive Species Task Force that was also created by the Select Board. Part of what we were studying doesn't necessarily impact zoning issues. However, in addition to the code complaints, there's also a deeper concern. We've all been out to Hammond Street. We've seen what those trees look like. They're dead. It's a beetle or some kind of a fungus or something is working its way through some of our forested areas. Cities like Worcester have had to cut down many of their urban trees because of the Asian longhorn beetle. Worcester's not that far away. My other concern, back to the invasive species, is that these folks are operating and bringing in truckloads of wood. So they're more than just cutting it on site, and they're chipping it on site, yes. They're importing this stuff, and we don't know from where.
Is this people who have like the firewood for sale? You drive around town, you see all that too? Is that?
Sometimes there's some folks even on Main Street who have a couple of cords of firewood. They would be outside of this. We're talking about
Okay.
commercial operations where this is a primary industry or part of the business or industry.
Oh, I've never seen any of
And
this
thereby
in
not
town.
exempt.
Okay.
There's a few folks who operate, and, I dare say, Newcomb Tree Service is someone who is reputable, operates throughout the community.
Mm-hmm.
They're not someone we're talking about, but it's kind of in that vein. Someone like Newcomb is of course regulated in another community.
Okay,
That type of business use is not regulated in town.
okay.
And frankly, just to hark on the imports of trees, if we do learn of an instance where an invasive species has impacted a community, I believe it's in our interest to know if a business operating in town is receiving wood from that community. It could very well introduce additional invasive species.
I've looked at with Stephen, at a couple of sites in Carver, and it was online, and you could see where people had done had logs on their property. So it wasn't that they were cutting, splitting firewood for their home. It appeared that they had hundreds of logs that they were on their property and piles of wood chips on their property. And so we really needed to come up with a regulation for this because, we've had fires on, was it Chip Tech in North Carver? And we had fires that have lasted for days. And so these things can be dangerous and dangerous to the neighbors that live around these things. And I think this was all brought to light by the neighbors who complained about, what was going on, just wanted to know if this was regulated or whatever. So, and the fire department has no way of controlling this right now. The fire department really has to have a way to get in there, they have to have a way to get around the wood chips, really have to, and we have to come up with these regulations for heights of the logs and heights of the wood chips, just in case there is a fire, and so, that's why we have to have, it's just not an odd thing, there's a couple, at least two, who knows, that, maybe more, and, so I believe that, for the safety of the community, this is important, amendment to have.
Are these businesses like paying commercial taxes now, or is this like people doing it in their backyard, kind of on the down low? Or both?
I don't know that
I
much
just-
about it. It's just what we viewed. I don't think it's nothing that's come before the board
Okay.
or any other of the
I mean, safety's
town hall.
huge. Safety's
Yeah.
so important. It's
Yeah,
but, I'm,
So that's why this has come about. No, these aren't existing businesses as the town knows them, I believe.
And Mr. Chairman, to contribute further still, I don't believe that anybody endeavors to do wrong. I believe that these bylaws are also intended to give guidance to folks who want to run this a legitimate business in town, but they're not aware that they probably should have a 100-foot setback or operate on a parcel much larger than, say, 60,000 square feet. I believe that by giving folks this level of guidance, it will produce a much better operation also. I think that the problems we've seen in the past were resulting from the absence of that guidance.
Exactly.
So, Mr. Chair, just to give the public a little bit of background and also this board and, this board previous board, when I was still on it, I think I was the only member at the time. At that time, in that board, we had approved Chip Tech on coming to North Carver, the Route 44, area. We didn't have any bylaw in place. I wish we did, because, it would have been essential for the way that that place was designed and built and operated. I was chairman at the time. I remember getting a phone call from Chief Weston that they had a fire up there on July 4th. And the fire department was there for days, weeks, fighting this fire. The fire was smoldering. And I'll never forget, and I want everybody to remember this phrase, because I will never forget this. Our firefighters are our neighbors, our brothers and sisters in this town. They fought this fire for weeks. And if the fire department or personnel ever went on one of these and it collapsed, there was no way that they were gonna be able to get that firefighter out of there. It's dangerous. Regulations like this are long overdue. I think it was well-written by the committee. I think we need it. I'll never forget Chief Weston's statement on that. I fully endorse this 100%.
Any other board members have anything to say?
No, I'm 100% behind it as well. We definitely need this.
All right, I see some hands out in the audience.
Rich Cirque, attorney in Plymouth. I'm having difficulty tying the discussion that I'm hearing to the list of zoning amendments in the handout. We finished the insertion of asterisks in zoning amendment 3. Zoning amendment 4 is the one that has to do with substituting zoning for residential. Which article are you now discussing?
We're discussing Amendment 4 for commercial wood processing.
Okay, I must have the wrong handout then.
You're welcome to this one if you'd like.
Okay.
And I'm realizing I wasn't scrolling, forgive me.
Anyone else in the audience have any questions or comments?
Mr. Chair, I'll make a motion to recommend zoning amendment 4 as presented.
I'll second.
So you have a motion and a second. Any further discussion? Seeing none, those for?
Aye.
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 Okay, so that's unanimous.
Mr. Chairman, zoning amendment 5 is the text for the use regulation table. What the board just approved to recommend to town meeting is to include this in the use regulation table. Zoning amendment 5 is the actual text that will govern the bylaw for commercial wood processing.
That doesn't have anything to do with the commercial processing. Stephen?
I think, is my zoning amendment 5 different than what you just said?
There are two full 5s.
Yeah, there are 2 5s.
Forgive me, anyone in the following in the audience, yes, there are 2 zoning amendment 5s. We're talking about the first zoning amendment
Okay.
5, which follows zoning amendment 4,
Okay.
which was the use regulation table for this use.
Okay. So this is zoning amendment 5 for the commercial wood processing operations.
Yes, yes.
And it gives us a definition, a purpose,
Oh, so we just added,
and applicability,
so now we
Yes,
added it.
we
now
added
And
it
the
in the use
setbacks.
regulation table, and now we're governing it.
Oh, I was
and
asking more
enforcement.
questions on that.
So now we're on zoning amendment number 5, the second one.
Well, no, we're still on zoning amendment 5, which is,
To be clear, zoning amendment 4 was to allow the commercial wood processing in the use regulation table. Zoning amendment 5 are the design standards.
Okay.
okay. Yeah, so it's a zoning amendment, this particular zoning amendment 5 says to add a new section, section 3660, to the Town of Carver zoning bylaw to allow for commercial wood processing operations. And then it gives all the definitions.
I got nothing.
So,
We just beat it up.
Yeah, I thought that's what we did.
and then we have a corrected sheet here too, don't we? Oh, this was for zoning amendment 4. Oh, I could see where, yeah, it is confusing. This one says 4, but actually it's this one here, which is 5. Here's the definition, here's the purpose, applicability. So we have a sheet with blue typing, and then it has,
Oh, disregard that. Those are lawyers' comments. I just want to see that you're looking at the right.
oh, okay.
Let's see.
Only Mr.
No, we're only looking at this. I don't know why this is a.
Yeah, this was included in the packet, in the back of the packet.
Oh, this is the one I gave you earlier, not the one I gave you tonight. before the
Yeah, I
meeting.
don't know if, oh, okay,
Yeah,
yeah.
you took one home with you earlier,
I
Mr.
did,
Chairman. That's,
yeah.
that's,
Going home.
that's the improper one.
All right,
'Cause then we can also
Okay,
sign all
okay.
that stuff.
okay, thank you.
I guess a half hour on top of being done.
All right, any questions or comments by the board members for this new section? Seeing none, anybody in the audience? Seeing no hands?
Make a motion to recommend zoning amendment 5 as presented.
I'll second that.
So we have a motion and a second for the discussion. Seeing none, those in favor?
Aye.
Okay, so that's unanimous. Okay, we just, okay.
So second zoning amendment number 5 is only about changing the word residential to zoning, right?
So we just voted on Amendment 5, and that was unanimous, so we'll go on to the second. It says zoning amendment 5, it says to amend section 5222 of the Town of Carver zoning bylaw to delete residential as shown below in a strike-through and add zoning as shown below in bold type.
That's correct, Mr. Chairman. So what is now, should be reflected as zoning amendment 6, does amend section 5222 to delete residential as shown and include, just add the word zoning. As folks may know, we have what is called a prohibitive bylaw. And so why we even have segmentation between adding things to the use regulation table and then adding some text to the bylaws is because if it doesn't appear in the use regulation table, it is theoretically not allowed in town. The fact of the matter is that the ZBA, I believe some members also agree to this, the ZBA does not believe, neither does the planning staff or town council, believe that the ZBA has the ability or the powers to issue a use variance. The way the bylaw is written presently, it specifies that the ZBA may not issue a use variance in residential agriculture districts. It is silent on other districts. It is therefore not allowed in other districts. We are codifying it so that it takes away any of the mysticism, so that there are no use variances allowed in any district in town.
Okay.
It does not interfere with the ZBA's ability to issue a dimensional variance, however. So if relief is still needed for dimensional purposes, that still may be achieved. If the underlying zoning, however, is a residential agriculture, by example, the ZBA and no other board or authority in town is able to change that to, say, highway commercial, without first going through the process of changing that zoning, which is a public process, requiring 2/3 vote of town meeting.
Any questions by any of the board members?
The only question I had is, what are we naming this one? Zoning Amendment 5A?
No, we're just gonna go
Six.
forward and move them up to
Just move them up
six.
one.
That would be my
okay.
recommendation,
Yeah,
as
okay.
they are unrelated to each other. What we had done was merge a couple of documents that were working
Okay.
projects.
Okay,
So I'll make a motion to accept.
well,
Oh,
let me open this up to the public. Is anybody in the audience have any questions about this? Seeing none? I'll entertain a motion.
I'll make a motion to strike residential and change it to zoning on zoning amendment number 6.
Second.
So I have a motion to approve zoning amendment 6 and a second.
Mr. Chairman, was that opened up to the public for a comment?
Yes,
It was,
yes,
okay.
I did, yeah. And so I have a motion and a second. Further discussion? Seeing none, those in favor?
Aye.
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 Okay, so that's unanimous. Okay, so zoning amendment 7. This is the, to amend Article 6 of the Town of Carver zoning bylaw, definition of craftsman, tradesman, to delete et cetera as shown below and strike through.
Fairly straightforward and explanatory. The word et cetera, ETC, appears in a definition in our zoning bylaw. I believe it's a matter of best practice as well as clarity for an applicant and the board that et cetera should not be there. It should be removed, in my opinion, as the et cetera refers to a subset of examples of handicraftsmen, such as a jeweler, a cabinet maker, et cetera. It does not refer to the exhaustive list of what is considered a craftsman tradesman, or to the rest of that definition. So rather than having any kind of confusion, we are seeking clarity in the bylaw by removing et cetera from the definition.
Now, if I could ask a question, I understand jeweler, I understand cabinet maker. What is a frame person?
I didn't write the law, sir.
So a frame person could actually be two definitions. It could be something who creates frames for pictures, and it could also be somebody as a builder.
Frames a house.
Who is considered a framer, carpenter.
The definition as it reads presently, craftsman/tradesman shall mean retail and/or service provided by a worker who practices a trade or handicraft, comma, one who creates or performs with skill or dexterity, especially in the manual arts, comma, such as a jeweler, cabinet maker, frame person, etc.
By doing this, though, by deleting et cetera, we're just limiting this to jeweler, cabinet maker, or a frame person.
Not necessarily, sir. There are pretty well recognizable craftsman, tradesman industries, a plumber. There are trades. I think that what this is intended to do is to clarify anyone who may not fit neatly into a category in our use regulation table, so that this can't be used to insert or infer that they are a craftsman or a tradesman.
Such as doesn't leave it as ambiguous, right? We want to get rid of any ambiguity and stretching of the et cetera. So do we have to tighten up such as too?
If it's the will of the board, it's my belief that et cetera just shouldn't be in any definition.
Yeah.
It just leaves it too open-ended. And when we have a prohibitive bylaw, frankly, it's antithetical to the purpose of the
Yeah.
bylaw.
Yeah, no, et cetera should definitely be gone. I just want to make sure, does such as
That's a
also
long way of
open-
saying it's up to you
Does
guys.
it open the same can of worms if we're getting et cetera to try to tighten things up?
Well, could. Yeah, I think, though, that the purpose for the such as, jeweler, cabinet maker, frame person, refers to the manual arts.
Okay.
Manual arts. I think that most folks will understand, and you can certainly Google and see what is considered a craftsman, or what is a tradesman.
Okay.
The such as and et cetera are in reference to manual arts. I ran that by an English teacher to make certain that that's where I read it.
So if I may, Mr. Chair, would it be a problem instead of such a, so you said you went to an English teacher for that?
Well, and town council as well, but yes.
So example wouldn't necessarily be okay opposed to such as?
I think we maybe want to get away from giving examples.
Okay.
I think craftsman, tradesman is pretty clear as it is. But it would be a poor use of the board's time, I think, to have that kind of a debate in public session. We're not Merriam-Webster's Board of
Simply wanna drop
Directors, we're the
that.
planning board. Correct.
Any other further questions, board members? Okay, we'll open up.
Mr. Chairman, okay, never mind, nope, you were doing the right thing.
All right,
I saw a hand in the audience.
I like to do the right thing once in a while.
Rich Cirque, an attorney in Plymouth. As the board probably knows, I represent the person whose petition generated this proposed zoning amendment. It has to do with the property at 157 North Main Street in Carver, which is the subject of a pending special permit hearing, which is on the agenda for tonight, but my understanding is will be continued for 2 more weeks. I am asking that this amendment have the following additional language. And the language would be as follows: provided that this amendment will not apply to any case in which a special permit application was filed prior to the date the amendment is passed by town meeting. I'll read that again. Provided that it will not apply to any case in which a permit application was filed prior to the date the amendment is passed by town meeting. The reason for that is, under the law, if a zoning amendment passes, it applies to any special permit issued after the first notice of public hearing by this board. Now, the first notice of public hearing by this board obviously preceded tonight. And so if a special permit is granted in the case of 157 North Main, which is what generated this amendment, without the language that I'm seeking to add, that amendment would reach back and affect this pending petition. And so out of a sense of fairness, I'm asking that any case in which an application for a special permit was filed prior to the date the amendment is passed at town meeting be exempted or grandfathered from this amendment. Because otherwise it just would be anomalous if the case that generated the amendment was one in which the amendment ended up biting the petition in the backside.
Mr. Cirque,
Yeah.
through you, Mr. Chair, could you provide us with that language?
Yeah.
And I would recommend that we reach out to town council to get clarification on the language and make sure that we have clear representation on the intent of what we're trying to do, vice what Mr. Cirque is presenting as an amendment to the article. Okay? So we'll hear everybody else, but I'm gonna motion to table it.
Anybody else have, anybody else out in the audience have any other, thank you, Attorney Cirque. Sure. Anybody else have any questions or comments? All right, seeing none.
Mr. Chairman, in lieu of the information that was provided us, I'm gonna make a recommendation, a motion to table this till our next meeting after getting a clarification from legal. That's a motion.
So we have a motion, do we have a second?
I will second that, I agree with that.
Okay, motion and a second, further discussion, those in favor?
Aye.
Okay, so that was unanimous. All right, okay, now we go, see, it is, I guess we can start, the
Ms.
marijuana.
We can certainly. I was going to ask, knowing we have 20 minutes before our regular meeting, and this most august board has been here for the last 90 or so minutes,
Yeah.
I was going to recommend, since we have to convene anyhow again, if it would be prudent or the will of the board to table the marijuana proposed amendment so we could have a more robust discussion about it at our next meeting, of the board's choosing. Is anyone, Mr. Chairman, through you, may I ask the audience if anyone here is to discuss the zoning amendment for marijuana in the audience? It appears
Okay.
not.
So that is going to be a long discussion. So I think that's a good idea if we just leave it here for now, and then we'll continue on with our regular meeting at 7 o'clock. But I'd like, see, when are we going to meet again for this, the marijuana bylaw?
And so March 5th was proposed when I had emailed each of the board members. I had laid out a tentative schedule. I think most members had expressed that what was there was acceptable, with the exception of 1 or 2 dates. Is that right, Ms. Bogart? 1 or 2
Just
dates maybe had to be
Maybe the 12th.
twinged?
I think.
So my recommendation would be that we reconvene on the 5th, and then at each meeting, we set our next meeting schedule. So that way it's frankly kind of conducive to how we do site visits and other follow-up meetings, given the nature of everyone's schedule.
So it would be March 5th at 5 o'clock?
5 o'clock.
So we'd be doing the same thing we're doing today.
Yeah.
However, focusing only on the 2 tabled items, which would be amendment
Convening for the council.
7 and 8.
For 7, and then going out.
Mr. Chairman, I'd like to make a motion to continue the public hearing for all the zoning articles to March 5th, 2019 at 5 PM.
So I have a
Second
motion and a second. Those in favor? Aye.
Mr. Chairman, I'd ask for a 5-minute recess. Is that a motion?
We'll reconvene. Right now, it's
20 of 7?
it's 6:41, yeah. So do you want to, so we have to start our meeting at 7 o'clock, our regular meeting?
We advertised 7, we should start at 7.
Yes, yeah. Okay, so we'll end this meeting, and we'll be back at 6:41, and we'll start our regular meeting at 7 o'clock.